What is the difference between a DWI and a DUI in Texas? This is a question I get a lot, and it's often because people are using those terms interchangeably. When people call for a consultation, they say, oh, I had a prior DUI, or I had a prior DWI, or a driving while ability impaired, which is something completely different. But is it really? So the way things work in Texas is that if you have a DWI, you are charged with being intoxicated while operating a motor vehicle. That could be in one of three ways. Having an alcohol concentration that is 0.08 or higher, which is the one we all think of, it's the most common, or not having the normal use of your mental and or physical faculties by the introduction of alcohol, a drug, a dangerous drug, or any combination thereof. DUI, on the other hand, is something that is specific to people who are under the age of 21. It doesn't require that you were actually intoxicated. It just requires that you had any detectable amount of alcohol in your system while you were operating a motor vehicle and you were under the legal drinking age in Texas. Where this gets complicated is other states have different laws. Different rules, different go-bys, different processes and procedures. Why it's important is that if you have an out-of-state prior or a DWI or DUI or driving while ability impaired in a different state, it could affect your charge here. The way the Texas law works is that if you have a prior offense for driving while intoxicated in another state, and the elements of that offense are consistent enough to Texas, then they can consider it a prior conviction. By considering it a prior conviction, you are now looking at an enhanced penalty range here in Texas. So whether that's a driving while intoxicated misdemeanor repetition or a third or more, which is a felony repetition, really depends upon the elements of the state in which you were convicted. So, for example, in Colorado, while we have a driving while ability impaired, which is a 0.05 standard, the other elements to that offense have to do with losing the normal use of your mental or physical faculties, and not exactly the same terms, but close enough where Texas has said it's sufficient. So you could have been convicted for a lower level offense in Colorado that then transfers to Texas as an enhancement offense, and you are now looking at a more serious charge. So be very careful when you are describing your potential charge to an attorney in a consultation, or you're talking about it to someone you may hire in the future. And that's because how they advise you and what their opinion is on the state of your case has a lot to do with what your criminal history looks like and what your priors are, and potentially what enhancements you could face as a result of those priors. Again, DUIs in Texas are for people under the age of 21, and it doesn't require that you're proven to be intoxicated. If you're under the age of 21 and you are found to be intoxicated, then you'll face a DWI like everybody of legal drinking age. A DWI is for persons 21 years of age or older, or anyone who's intoxicated by alcohol, a substance, a narcotic, a dangerous drug, or any combination thereof. Well, I hope that helps. And if you have any other questions, feel free to comment below. Again, my name is Anna Summersett. I'm one of the partners here at Varghese Summersett Law Firm. Thanks for watching.